Welcome to Talk Trials.
It's great to be here.
This is the show where we take a professional, unwavering look at the Federal Circuit Court of Appeals opinions that are actively shaping the landscape of intellectual property law. We don't do surface level here. We don't do too long, didn't read. We are here to analyze the arguments, dissect the judicial reasoning, and really get into what these rulings mean for practitioners, for the industry, and, for the rule of law itself.
Exactly. Our goal is to be legally rigorous, but I hope entirely accessible. Whether you are a senior partner, an in-house counsel managing a portfolio, or frankly, just someone fascinated by the complex machinery of the federal courts, we want to get to the heart of what matters.
And today we have a monster of a case on the docket. It's a decision that came down right before the holidays, actually, December 23, 2025. The case is Ethanol Boosting Systems, LLC v. Ford Motor Company.
A very significant way to end the year 2025. This comes from a panel of circuit judges Chen, Clevenger, and Hughes, with Judge Chen authoring the opinion for the court.
And when you look at the caption, you see quite the cast of heavy hitters. On the appellant side, we have Ethanol Boosting Systems, which we'll just call EBS, and they're appearing alongside the Massachusetts Institute of Technology, MIT.
So you've got the commercial arm and the academic powerhouse right there.
Right. And on the appellee side, you have the automotive giant Ford Motor Company.
But there is a third player here, right?
There is. Intervening, as is so often the case in these kinds of procedural battles, is the director of the United States Patent and Trademark Office.
And that lineup alone, that just signals this is going to be a heavy fight over procedure. When the director of the USPTO steps in to intervene, it usually means the structural integrity of the inter partes review system, the IPR system, is being challenged in some fundamental way.
Okay, so let's set the stage. What is our mission for this deep dive? What are we trying to unpack here?
We are going to unpack a really complex, multi-layered interaction between district court claim construction, what words in a patent mean in a trial, and the discretionary powers of the Patent Trial and Appeal Board.
The PTB.
The PTB. And specifically, we're looking at the scope of appellate review under 35 USC Section 314DA.
The famous no appeal bar. The fortress.
It's the very same.
Yeah.
But we can't ignore the technology underneath it all. At the core of this legal procedural storm is this fascinating piece of engineering regarding fuel management systems and anti-knock agents in internal combustion engines.
It's a classic example then, high-level administrative law colliding head-on with some pretty hard engineering.
Exactly.
Before we get lost in the weeds, let's give everyone the snapshot. What was the holding? What's the bottom line?
The Federal Circuit affirmed the board's decisions, straight down the line. The result is that claims across three different patents, the 580, the 760, and the 965 patents, all of them remain unpatentable as obvious.
So EBS and MIT lose the patents. They are out. What was the core rationale that led the court to this affirmation?
It really breaks down into three distinct pillars. First, procedure. The court just completely rejected an attempt by EBS to essentially deinstitute the proceedings. EBS was furious about a massive administrative delay, a 15-month pause that they said was unlawful.
And the court said?
They cited the statutory bar on reviewing institution decisions to just shut that argument down.
That is the fortress of Section 314 we keep talking about.
Precisely. The second pillar was claim construction. The court rejected an attempt by EBS to bind the board to a prior, unappealed district court construction about whether gasoline counts as a fuel.
Right. This is what you were calling the zombie argument.
We'll get into why. It's the perfect name for it. And third, on the merits, the court found there was substantial evidence to support the board's findings on obviousness based on the prior art combinations Ford presented.
Just reflecting on the tone of this opinion before we really dive in, it feels like a significant reinforcement of the status quo, doesn't it? About the board's power.
It absolutely is. It reinforces the view that the PTAB has immense discretion to manage its docket. It tells practitioners that once that train leaves the station on institution, it is very, very hard to stop it based on procedural grievances.
And it's a warning about claim construction.
A stark warning. You cannot just rely on what happened in a different courtroom years ago. You have to make your case again from scratch.
Okay, let's unpack this. I want to start with the technology and what we're calling the ping-pong procedural history. Because usually procedure can be, a little dry, but here the procedure is the story. It's a chess match.
Agreed. But to understand the chess moves, we have to understand the board. We have to look under the hood, so to speak.
So the technology deals with engine knock. Now, I drive a car, but I'm not a mechanic. When I hear knock, I think of someone at the door. What is engine knock in this context?
So think of the cylinder in your car's engine as a very precise, very high-speed room. In a normal cycle, you mix air and fuel, a piston comes up and compresses it, and then a spark plug ignites it at the perfect moment.
And that should be a controlled burn, right? Like a wave of fire pushing the piston down smoothly.
Exactly. It should be a smooth push. Knock is what happens when that mixture detonates prematurely or just unintentionally. It's an uncontrolled explosion inside the cylinder. So instead of that smooth push, it's a violent shock wave.
That sounds incredibly damaging, like a tiny bomb going off at the wrong time.
It is. I mean, imagine taking a sledgehammer and just hitting the top of the piston while it's trying to move up. It creates a very distinct pinging or knocking sound, hence the name, but more importantly, it reduces efficiency, and over time, it can literally destroy the engine. We're talking melted pistons, damaged cylinder walls. It's bad news.
So solving knock is sort of the holy grail for engine efficiency.
It really is. Because if you can stop knock, you can run the engine at higher pressures, higher compression ratios, which gives you more power and better fuel economy from the same amount of fuel. The patents here propose a solution using a dual injection system.
Dual injection, so two different ways of getting fuel into that cylinder.
Correct. You have port injection, or PI, and direct injection, or DI. Think of them like two different ways to water a garden.
Okay, I like analogies. Hit me with it.
Port injection is like setting up a sprinkler in the hallway leading to the garden. The fuel is sprayed into the intake port, this little passageway, where it mixes with the air before it even enters the cylinder. It creates a very well-mixed, homogeneous charge. This is typically used at lower torque, when you're just cruising.
Okay, so that's the standard gentle way. What's direct injection?
That is exactly what it sounds like. It's like taking a high-pressure hose and spraying it directly onto the plants, spraying the fuel directly into the cylinder itself, usually during the compression stroke. This is generally used at higher torque when you're accelerating hard.
And the mechanism in these patents, the secret sauce, relies on that direct injection.
Yes. The idea is you directly inject an anti-knock agent.
So when the engine is working hard and it's on the verge of knocking, you spray the special agent directly in.
Exactly. And here's the cool part, the physics of it. When you spray a liquid directly into a hot pressurized cylinder, it evaporates almost instantly. And that evaporation absorbs a massive amount of heat. It's called evaporative cooling. It chills the air-fuel mixture right at the critical moment, which prevents that premature detonation.
So it cools things down just enough to stop the uncontrolled explosion.
It's the whole game.
So that is the tech. It seems elegant. You have a cruising mode with port injection and then a high-performance anti-knock mode with direct injection. But the legal fight over this elegant tech is anything but simple. This case has bounced back and forth like a ping pong ball.
It has. And understanding this timeline is absolutely crucial to understand the ultra-virus argument we'll get to later. We really have to look at this in phases.
Okay, let's call phase one the district court battle.
Right, so this all started years ago. EBS sues Ford for patent infringement in district court. Immediately, a dispute arises over what the parties call the DI fuel terms. They had to define what the patent meant by direct injection fuel.
And definitions are everything in patent law. We say it every time. If you define a word narrowly, you might avoid infringement. If you define it broadly, you might invalidate the patent with prior art.
Exactly. It's the whole battlefield. So Ford proposed a construction that the district court adopted, and it had two critical parts. Part one, the direct injection fuel must be different from the port injection fuel.
So it has to be a dual fuel system. You can't just use gasoline for both. It's got to be, say, gas in the port injector and ethanol in the direct injector.
That was Ford's argument. And then there was part two, the anti-knock agent cannot be gasoline.
So Ford is building a very narrow box for the patent. They're arguing, your patent is for this very specific system that uses something special, like ethanol, as an anti-knock agent. Our cars just use gasoline in different ways, therefore we don't infringe.
That was the strategy. And it worked. Based on that narrow construction, EBS effectively lost the case. They stipulated to non-infringement, basically saying, well, okay, under that definition, Ford wins. And then they appealed.
Which moves us to phase two, the first appeal. We'll call this one EBS-I.
Now, here is the plot twist that really haunts this entire case. When EDS appealed to the Federal Circuit the first time, they appealed only part one of that construction.
Just the different fuel requirement.
Yes, they argued about the different fuel requirement, but they stayed completely silent on the no gasoline requirement.
Wait, really? So they did not challenge the district court's ruling that the anti-knock agent cannot be gasoline?
They did not. They let it lie.
That feels like a massive oversight or a huge gamble.
It's one or the other. Maybe they thought they could win on the first point, and that would be enough to revive their case. And to their credit, they did win on that first point. In EBSI, the Federal Circuit vacated the district court's decision. They ruled that the different fuel requirement was legally incorrect.
Why was it wrong?
Because the patent's own specification, the written description, actually disclosed an embodiment where a single fuel was used for both injectors.
So they won the battle on different fuels, but because they didn't appeal the no gasoline part, that part of the district court's ruling just sat there.
Yeah.
Unchallenged.
It sat there, a ghost in the machine. Now we move to phase 3, the P-tape shuffle. This is where it gets really procedural. While all this court drama was happening, Ford was fighting on another front. They had filed petitions for inter partes review, IPRs, at the patent office to challenge the validity of the patents.
The classic two-front war. Sue them in court for infringement and try to kill the patents at the PTT.
A pincer move. And initially, the board actually denied Ford's petition.
They said no to Ford.
They said no. And the reason this is fascinating, they did it because they were following the district court's logic. At that time, before the appeal was decided, the law of the case was that the fuels had to be different.
So the PT looked at Ford's prior art and said, this doesn't show two different fuels, so it doesn't apply under the current claim construction.
Exactly. The board said, we're not instituting. Ford, you haven't shown a reasonable likelihood that you'll win.
But Ford obviously didn't give up.
Ford asked for a rehearing. They effectively said, hey, wait a minute. That claim construction is on appeal. Let's look at this again. And here is where the timeline gets really sticky. The board essentially hit the pause button. They stayed action on Ford's rehearing request.
For how long?
For 15 months.
15 months. That is a lifetime in the business world. If I'm a startup like EBS trying to enforce my patents, that is an eternity of legal bills and uncertainty.
It's a huge delay. And the board waited specifically until the Federal Circuit decided EBSI. They wanted to see if the appellate court would change the definitions, change the rules of the game.
Which they did.
Which they did. Once EBSI came down from the Federal Circuit and said, hey, the fuels don't have to be different, the entire landscape shifted. The board then said, aha, the controlling claim construction has changed. They granted Ford's rehearing, applied the new broader definition, and instituted the IPR.
Which, of course, brings us to the current case, EBS2. EBS is furious about this 15-month delay. They're arguing that the board broke the rules by waiting that long.
And that leads us right into segment 2 of our deep dive, the ultra-virus stay argument.
This is a pure jurisdiction question, right?
It is. EBS argued that the board lacked the authority to stay the rehearing decision for 15 months. They claimed this was an ultra-virus action.
For our listeners who aren't lawyers, what exactly does ultra-virus mean?
It's Latin for beyond the powers. It's an argument that a government agency acted outside of the legal authority granted to it by Congress. EBS is essentially saying you aren't allowed to just sit on a case for a year and a half to wait for a more favorable legal wind to blow. Your rule book doesn't allow for that.
And if the action was beyond their powers, their argument is that the eventual institution of the trial was void from the start. It's a fruit of the poisonous tree argument.
Precisely. If the delay was illegal, the trial shouldn't have happened, the board's final written decision should be vacated, and the patents should be safe from this particular challenge. They wanted the court to deinstitute the IPRs. Just throw the whole thing out.
But the Federal Circuit ran into a very large, very sturdy wall called 35 USC Section 314 TIS. We talk about this section a lot, but explain why it's such an incredible hurdle for appellants like EBS.
It's the statutory bar. Section 314T is, it's about as explicit as a statute gets. It states that the determination by the director to institute an inter partes review is final and non-appealable. Congress put that language in the America Invents Act specifically to prevent patent owners from stalling the IPR process with endless appeals about whether the trial should have started in the first place.
So once the trial starts, you can't go back and appeal the decision to start it. The train has left the station.
That's the idea. And the court here cited the big Supreme Court precedents in Thrive v. Click to Call and Quazzo. These cases establish that if your appeal is, at its core, an attack on the institution decision, or something very closely related to it, like the decision to reconsider institution, the courts simply do not have jurisdiction to hear it.
But EBS tried to be clever, didn't they? They tried to thread a very fine needle. They said, we aren't attacking the institution decision itself. We're attacking the stay that came before it.
Right. They framed it as, we're fine with the board's power to institute, but we are challenging the refusal to act for 15 months. That's the illegal part. Judge Chen, writing for the panel, did not buy it. He called it a distinction without a difference.
And why is that? Why isn't that a valid distinction?
Because you have to look at the relief EBS wanted. What were they asking the court to do? They were asking for the termination of the proceedings. The court basically said, look, you're attacking the timeline that led to the institution. An attack on the process of reconsideration is functionally an attack on the institution itself. If we grant your relief, the IPR disappears. It's a backdoor challenge, and therefore Section 314T applies and bars our review.
Is there any exception to this rule? I feel like we've talked before about the shenanigans exception.
Ah, yes, the shenanigans. That comes from Justice Breyer's language in Quoso. It's a very, very narrow exception for when the agency does something that is just so far outside its statutory scope, it's absurd. The classic example everyone uses is if the board tried to cancel a patent for being indefinite in IPR.
Which they aren't allowed to do, right? The statute limits IPRs to novelty and obviousness challenges based on patents and printed publications.
Exactly. If the board started canceling patents because they didn't like the font size, or for subject matter eligibility, or something else completely outside their mandate, that would be a shenanigan. That would be a truly ultra vires act that a court could potentially review.
So the million-dollar question, was waiting 15 months a shenanigan?
The court said not even close. They ruled that waiting for a relevant appellate decision, in this case EBSI, is not a shenanigan. Judge Chen called it a sound reason to pause.
It makes a certain amount of sense from an efficiency standpoint, doesn't it? Why start a massive, expensive trial based on a legal theory about different fuels that the Federal Circuit might completely overturn in a few months?
That was the board's logic, and the court's too. Why waste judicial and party resources? And legally, there is no statute that requires the board to decide a rehearing request within a specific time frame. There's a deadline for the initial institution decision. That's in the statute. But for a rehearing request, there is no shot clock.
So because there's no statutory deadline, waiting isn't illegal.
Exactly. It might be frustrating. It might feel profoundly unfair to the business that's in limbo. But it isn't a statutory violation that rises to the level of a shenanigan. So the court said, our hands are tied. The challenge was barred from review.
So the procedural attack fails. The fortress of 314 TAC holds strong. Now we move to segment 3, which I find even more fascinating from a legal strategy perspective. The zombie claim construction.
It is a very apt description. EBS is trying to bring a dead argument back to life, an argument they themselves let die. The dispute here is all about whether gasoline can be the anti-knock agent.
Remind us again why EBS cares so much about this. Why are they fighting so hard to say their own patent doesn't cover gasoline? It seems counterintuitive.
It absolutely does. Usually patent owners want the broadest possible claims to catch as many infringers as possible. But here, they're on defense. They're trying to save the patent from being invalidated. Ford's prior art, the older inventions that might make this one obvious, largely relies on gasoline systems.
So the logic is, if fuel includes gasoline, then the prior art is very close and likely kills the patent. But if fuel can be defined to exclude gasoline, then the patent is novel and survives because it's distinct from all that old prior art.
That's their only path to victory. They needed to narrow the claim to save it. So their argument was this. Hey, remember phase 1 years ago? The district court said the anti-knock agent cannot be gasoline. We didn't appeal that part in EBSI. Therefore, that unappealed part of the ruling is controlling law. It is the law of the case.
They threw the whole legal kitchen sink at this, didn't they? I see in the opinion they invoked the mandate rule, waiver, and even judicial estoppel.
They used every procedural doctrine they could think of to argue that the board was handcuffed. They pointed to a PTAB rule, Rule 42.10, and argued it required the board to adopt the district court construction because it had been settled in that other litigation.
And what was the Federal Circuit's response to that line of argument?
It was a resounding rejection on multiple levels. First, on the procedure. The court clarified that the law of the case doctrine does not apply across different cases. A district court infringement case and a PTAB validity proceeding are separate tracks. They're parallel universes.
So just because a district court decided something in case A doesn't mean the PTAB is automatically bound by it in case B.
Especially on an interlocutory issue that was never finally adjudicated and appealed. It just doesn't carry over. And then there was a forfeiture issue too, which is a massive practice tip for any litigator listening.
What happened there?
It's just a critical mistake. EBS argued to the board that the no gasoline construction was controlling law, but they never actually argued the merits of the construction to the board. They relied entirely on this procedural argument.
So they didn't go to the board and say, you should interpret fuel to exclude gasoline because of evidence from the patents text, from the prosecution history, et cetera. They just said, the district court said so, so you have to listen.
Exactly. They put all their chips on the procedural argument. So when the board said, sorry, we aren't bound by the district court, EBS had nothing left to fall back on. They had forfeited the actual argument on the meaning of the words.
And the court said the board didn't abuse its discretion by just using the plain and ordinary meaning of the word fuel when neither party had briefed an alternative on the merits.
But the court didn't stop there. And I love when they do this. Judge Chen went on to kick the tires on the substantive argument anyway. He essentially said, and even if we listened to your forfeited argument, you would still lose. And here's why.
So why would they have lost on the merits?
Because of the specification. This is the classic preferred embodiment problem. The patent text, written by the inventors themselves, expressly discloses a gasoline-only mode of operation.
You're kidding. So the patent manual itself says you can run this engine using only gasoline.
Yes. And there's a fundamental bedrock principle in patent law. You generally cannot construe a claim to exclude embodiments that are explicitly disclosed in your own specification. The court cited the Otico case for this.
It makes perfect sense when you say it out loud. You can't write a patent that says, I invented a machine that runs on fuel, describe in detail a mode where it runs on gasoline, and then later come to court and tell a judge, oh, but by the way, fuel doesn't mean gasoline.
It creates a logical paradox. The court won't let you disavow your own invention. If your specification says a gasoline-only mode is an embodiment of the invention, then the claim covering that invention must be broad enough to cover gasoline.
What was EBS's response to that? How did they try to get around their own words?
They try to argue that the patent says other fuels, like ethanol, work better, or that the primary embodiment uses ethanol.
But better doesn't mean exclusive.
Exactly. The court said that doesn't matter. Fuel means fuel. And gasoline is a fuel. The zombie construction was dead on arrival, and then the court shot it again for good measure.
Okay, so the procedural attack fails. The claim construction attack fails. That leaves us with the actual merits of the case. The obviousness finding. This is segment 4.
Right. So now we're into the nuts and bolts of the prior art. The board found the patents obvious on 2 separate and independent grounds. Let's look at ground 1 first. This involved the combination of 2 prior art references named Schrey and Mura.
These always sound like a detective duo. Who are Schrey and Mura? What did they teach?
Schrey is a reference that teaches a system with 2 direct injections, one during the intake part of the cycle and second one later during the compression phase. Mura is a different reference that teaches using port injection, the sprinkler in the hallway, specifically for knock suppression.
And the combination that Ford proposed was?
Ford argued, and the board agreed, that a person of ordinary skill in the art, a skilled engineer, would have been motivated to combine them. Specifically, to take the Schrey system and swap Schrey's first direct injection for Mura's port injection.
Okay, and this is always the key question in an obviousness analysis. Why? Why would anyone do that? You can't just mash patents together like Lego blocks unless there is a good reason an engineer at the time would have actually done it.
That was EBS's core argument on appeal. They argued there was no motivation to combine because of issues with homogeneity, basically how well the air and fuel mix. They said Schrey and Mura were trying to do opposite things. They argued that Schrey wanted a stratified charge on even layers of fuel, while Mura wanted a perfectly homogeneous mix.
So they're saying the 2 technologies are fundamentally incompatible. They have different goals.
Right. But the court upheld the board's finding. The board found a motivation to combine them to achieve the benefits of good mixing and stable combustion, particularly at low engine loads. Port injection is just better at mixing air and fuel when the engine isn't working hard. The court said that combining different known knock suppression approaches, taking the best of both worlds, is a perfectly valid motivation for an engineer.
It's the best of both worlds argument. An engineer looks at Schrey and says, this gives me good high-load performance, then looks at Mura and says, this gives me good low-load mixing and stability, and it would be obvious to combine them.
Precisely. There was also a secondary dispute about a specific claim limitation. The 3-way catalyst.
Right. The patent claims require a three-way catalyst to reduce emissions.
So the board had to find that in the prior art. They found that a reference in Schrey to a catalytic converter 46 taught this limitation. EBS, of course, argued, Schrey just says catalytic converter. It doesn't explicitly say it's a three-way catalyst.
Very fine distinction.
It is. But the court found there was substantial evidence in the record, including expert testimony, that in the context of this type of engine from that time period, a skilled artisan would have immediately understood that catalytic converter 46 was a three-way catalyst. It's just a standard component in emissions control.
Okay, so ground one holds up. Now let's look at ground two. This involved a different combination of prior art. Robert, Yashiro, and Bosch.
Right, so Robert is a reference that teaches about fuel mixtures and engine load balancing. And Yashiro teaches about using fuel maps, which are basically software control schemes for switching between different injectors based on engine conditions.
Now, EBS had a really interesting argument here. They essentially tried to use the board's own words against it. They said the board contradicted itself.
This goes all the way back to the ping-pong history. Remember, the board initially denied institution of the IPR. In that initial denial, the board had said there wasn't enough evidence to show why someone would modify Robert. They said Ford hadn't explained how or why you would change Robert's fuel maps.
So EBS's lawyers get up on appeal and say, Your Honors, the board said no before. They can't just change their mind. They already decided this point.
But the board can and should change its mind when the record changes. The Federal Circuit shot this down pretty quickly. The court noted that the previous denial of institution was based on a lack of evidence at that early stage. But in the full trial, the IPR itself, Ford provided new evidence.
They filled in the gaps.
They filled in the gaps. They brought in the Yashiro reference and new expert testimony that specifically explained why a skilled artisan would modify Robert's system to utilize the full knock limit of the engine.
So better evidence leads to a different result. That seems, well, fair. That's the point of a trial.
It is the standard process. You cannot bind a final decision to a preliminary institution decision that was based on a much thinner record. The whole point of the IPR trial is to develop the record. If Ford brings better experts and better prior art and better arguments to the actual trial, the board is allowed to be persuaded by it.
So across the board, on procedure, on claim construction, on the merits, EBS strikes out.
A clean sweep for Ford in the USPTO. A complete affirmance.
I want to zoom out now. Let's talk about the legal context and significance of this. We've covered a lot of ground, but what are the big takeaways? What should you, our listener, really remember from this case?
First and foremost, it is the sheer power of institution discretion. We have to reiterate just how difficult it is to challenge the USPTO's internal procedural handling of instituting an IPR.
If the director or the board wants to wait 15 months for a parallel court case to finish, that is their prerogative, and there's not much you can do about it.
And the Federal Circuit will almost certainly view that as a sound reason that is shielded by Section 314 feet. It essentially allows the PTO to manage its own docket without fear of constant interlocutory appeals disrupting the flow of cases. The fortress is high and the moat is deep.
The second big takeaway has to be about claim construction strategy.
This is a massive lesson for litigators. The danger of relying on law of the case from a parallel proceeding is very, very real. You cannot simply walk into the PTT, point to a district court ruling, especially a partial, unappealed, interlocutory one, and say, we already won this issue over there.
You have to re-argue your points on the merits every time.
You must. You have to treat the PTAB as a blank slate on claim construction. Argue the merits from the text of the patent, from the prosecution history. Don't rely on procedural shortcuts or waiver arguments from another venue. If EBS had vigorously argued why gasoline should be excluded based on the patent's own text, rather than just saying some other judge said so, they might have at least had a fighting chance on that issue on appeal.
But even then, they had that huge problem of the specification itself.
Right. And that's the third takeaway. The bar for disclaimer or disavowal of claim scope is incredibly high. Even if your patent's text says other fuels work better or are preferred, if the patent also mentions a gasoline-only mode, the courts will not exclude gasoline from the scope of your claims.
You can't draft a patent that covers a system, describe a mode of operation for that system, and then later claim that mode isn't actually covered by the patent.
It's a fundamental issue of logical consistency. If you built it in your disclosure, you've claimed it.
All right, it is time for our favorite segment. It is time for the 10th chair.
This is where we step off the reporter's podium and sit as the hypothetical 10th judge on the panel.
And as always, remember, this is our independent analysis. It is commentary for informational and discussion purposes only. It is not legal advice, and it does not represent the actual holding or views of the Federal Circuit.
That being said, how do we vote?
Sitting as the 10th chair, I am voting to affirm. I agree with Judge Chen and the panel completely.
I'm right there with you. It's a clear affirm for me as well.
Let's talk reasoning. On the procedure, for me, the statutory wall of Section 314 TAMA is absolutely intended to prevent exactly this kind of procedural entanglement.
I agree completely. Look, is the 15-month delay ugly? Yes. From a business perspective, it's terrible. If I were the CEO of EBS, I would be furious. My business is in limbo, the meter is running on legal fees. But from a legal systemic perspective, if we allowed appeals on delays in institution, we would clog the appellate docket beyond recognition.
Every time the board hesitated or extended a deadline or just managed its calendar, a party would file an appeal claiming it was an ultra-vires action.
Exactly. It would completely undermine the efficiency and finality that Congress was trying to build into the American Invents Act. The system relies on the board being the gatekeeper. You can't sue the gatekeeper for keeping the gate closed a little longer than you like.
And on the claim construction, that gasoline argument felt like a Hail Mary to me from the very beginning.
It really did. The moment I read that the patent specification explicitly mentions gasoline-only modes, the case on that point was over in my mind. It strains all logic to argue that a patent covers a system, but excludes its own fallback operating mode that is described in the text.
It felt like they knew they were weak on the merits of the construction, so they tried to win on a procedural technicality waiver mandate rule rather than on the actual technology, and the Federal Circuit usually sees right through that.
And finally, on obviousness.
To me, it's a classic KSR rationale.
Absolutely. The combination of known NOx suppression techniques, direct injection, and port injection is a predictable result. Engineers have been playing with different fuel injection strategies and mixes for decades. Combining them to optimize performance across different torque ranges is exactly the kind of thing we expect skilled artisans to do. It's evolutionary, not revolutionary.
So looking forward, what is the practical impact of this decision?
I think this ruling will likely encourage the PTT to manage its docket even more aggressively. They know now, with the Federal Circuit's explicit blessing, that pausing to await guidance from a parallel Federal Circuit appeal is a safe, unreviewable procedural tool. We might see more of these strategic stays when there's related litigation active.
Which brings us to our conclusion.
To recap, the board has affirmed Section 314 bar's review of the 15-month stay delay. Fuel means fuel, and that includes gasoline, because the specification says so. And the prior art combinations rendered the dual injection claims obvious.
A tough day for EBS and MIT, but a very clarifying day for patent law procedure.
Indeed.
So I want to leave you, the listener, with a question to mull over. We talked about the efficiency of the board's 15-month stay. It makes sense for the system. But does the inability to get judicial review of such a long delay grant the USPTO too much power? Does it give them the ability to manipulate patent life cycles and leave smaller companies in an administrative limbo that can be just as damaging as a final loss? Or is it simply a necessary, if sometimes painful, efficiency tool?
That is the fundamental tension at the heart of the administrative state, isn't it? Efficiency versus accountability. And in this case, efficiency won the day.
Something to think about. Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Federal Circuit.
Always consult your own counsel.
Thanks for listening to Talk Trials. We'll see you on the next docket.
Bye-bye.